Buenos días a la audiencia del Espectador que se conecta a esta hora a la transmisión del segundo día de audiencias por la demanda que Nicaragua instauró contra Colombia en 2013 y que ha recibido el nombre de supuestas violaciones a derechos soberanos y marítimos de Nicaragua. En este segundo día de audiencias, Colombia tuvo la oportunidad de responder a los argumentos que presentó Nicaragua para sustentar su demanda. Recordemos que en esta nueva demanda que instauró el país centroamericano, pues no se está discutiendo ya ni sobre tierra ni sobre mar, sino sobre, de nuevo, derechos que Nicaragua asegura Colombia le ha vulnerado. Por ejemplo, inicialmente indicó que a través del uso de la fuerza. Sin embargo, la Corte Internacional de Justicia, que tiene sede en La Haya, declaró que no tiene competencia para decidir sobre eso, sino sobre otro tipo de violaciones. Y Nicaragua centró su intervención del lunes en decir pues, que Colombia, por un lado, no ha cumplido el fallo de 2012 que le otorgó 75.000 kilómetros cuadrados de mar que inicialmente eran de Colombia a Nicaragua. Y centró también su intervención en decir que naves o embarcaciones nicaragüenses han sido impedidas o Colombia les ha impedido pescar en aguas que son de Nicaragua. Entonces, en este segundo día de audiencias, desde las 4 de la mañana hora Bogotá, que son las 8 de la mañana hora La Haya, en Países Bajos, ha estado Colombia defendiéndose, primero en cabeza del agente colombiano Manuel José Cepeda, ex magistrado de la Corte Constitucional, quien dirige el equipo de defensa de Colombia junto a Carlos Gustavo Arrieta, el ex procurador general de la Nación. Sin embargo, quien habló fue Cepeda y sus intervenciones se centraron principalmente en, primero, decir que pues, Colombia sí ha cumplido el fallo de 2012, pero que pues, la Constitución colombiana desde 1991 exige que los límites fronterizos de Colombia sean pues definidos a través de tratados internacionales y en este caso no hay un tratado internacional vigente con Nicaragua. Recordemos que el tratado que había antes de la demanda que Nicaragua puso en la Corte en 2001 era el Tratado Bárcenas-Guerra y es precisamente pues este tratado el que deja de perder vigencia casi con la expedición de la decisión de 2012. Sin embargo, pues esta interpretación pues, fue ratificada por la Corte Constitucional y el agente colombiano Manuel José Cepeda llamó a estos pedidos extravagantes por parte de Nicaragua. Nicaragua, dijo Cepeda, se fue de las conversaciones y pues textualmente dijo el agente colombiano Manuel José Cepeda: Colombia dejó la puerta abierta, Nicaragua la cerró, refiriéndose a negociaciones que se dieron hasta 2015 en las que se pretendía llegar a un nuevo tratado internacional, pero no fue posible. Finalmente, pues Cepeda se refirió a puntos muy específicos de la intervención de Nicaragua, como fueron que la gente nicaragüense citó dichos del expresidente Santos y del presidente Iván Duque, refiriéndose en esencia a que Colombia pues, no podría aplicar la decisión de la Corte, pues de nuevo porque necesita un tratado internacional. Cepeda dijo que pues si bien estas declaraciones sí fueron ciertas, fueron sacadas de contexto y que realmente pues, en Colombia debatimos un montón. Y dijo, cito, que esta es una realidad democrática que probablemente escapa la comprensión de Nicaragua. Sobre el argumento de que Colombia ha impedido la pesca de embarcaciones nicaragüenses, el abogado Manuel José Cepeda dijo que pues, las estadísticas de pesca de Nicaragua prueban lo contrario, que de hecho ha aumentado exponencialmente la cantidad de pesca ejercida por Nicaragua y que incluso se puede hablar de una pesca depredatoria por parte del país centroamericano. Finalmente dijo que hay 3 razones por las que Colombia hace presencia en aguas de la zona económica exclusiva de Nicaragua. Primero, pues porque hay un derecho internacional que es la libertad de navegación, que es uno de los puntos que probablemente será más discutido en esta controversia y sobre el que hay mayor expectativa, dado que la Corte Internacional de Justicia no tiene muchos pronunciamientos sobre cuáles son los límites o cómo definir la libertad de navegación. El segundo es porque en este lugar, en esta zona en disputa, está la reserva Seaflower, que desde el año 2000 fue reconocida por la UNESCO y cuya vigilancia pues siempre ha estado casi en manos de Colombia. La tercera razón es por la presencia de las autoridades en operaciones transnacionales contra el narcotráfico y contra otras formas de crimen organizado. Y finalmente, una razón aparte que es que tiene que ver con el personaje que estamos viendo ahora en pantalla, es la soberanía que tiene Colombia sobre el archipiélago de San Andrés, Providencia y Santa Catalina. Entonces, uno de los argumentos centrales de Colombia es que Nicaragua está violando los derechos de Colombia sobre las aguas contiguas a el archipiélago de San Andrés y Providencia, y que está violando los derechos ancestrales de la comunidad raizal que habita este archipiélago, y precisamente un miembro de la comunidad raizal fue el primero en intervenir por parte del equipo de defensa colombiano. Su nombre es Ken Francis James, es un líder raizal, y bueno, vamos a dejarlos con las imágenes de su intervención.
African men and women were brought in large numbers to the archipelago through enslavement owing to the customs of human trafficking at the time.
The Republic of Colombia before the International
But in
Court
many
of Justice,
aspects,
in this great hall
language,
of justice.
religion,
Madam
customs,
President, allow
the
me to
British
convey to you my
markedly
deepest gratitude for
influenced the
having rendered
raizales,
homage to the
hence the
late
Puritan
James Crawford,
heritage.
a renowned professor and
Almost
admired judge
200
of
years
this
ago,
court. He was well known
when the
to
United
Colombia.
Kingdom
As you
ended
noted,
the
prior
trade of
to acceding to the
slaves,
bench, he
a
was
son
lead
from
counsel
the
for
island of
Colombia in a
Providencia,
case involving our territorial
Beekman
and maritime
Livingston
interests
Jr.
before the same
of
tribunal.
British parents.
My country joins in the tribute to his memory,
In his early
regrets his
20s,
loss, and honors
also
his legacy.
began in 1834
Let me start by
a
addressing
campaign for
up
the
front
emancipation
what we heard on Monday
of blacks
from
in
the
the
agent
area,
of Nicaragua,
which included
Mr. Carlos
the Mosquito
Arguello.
Coast and the Cairn Islands.
He attempted to present an image of
He
Colombia
freed
as a rogue
the
country
slaves from his
that does
family,
not care about the law or
giving
this high
them
court.
property and
If this were
land,
the case,
instructing them to read, write, and in mathematics, as well as organizing entrepreneurial activities for their own benefit. His acts of humanity influence others to also emancipate all those enslaved on the islands. The raizales then began planting coconut for export to the United States of America. Other products, such as bird eggs and guano, were also of economic interest. But the main livelihood for the raizales has always come from the sea. For the raizales, the sea is home, shelter, livelihood, and support. The raizales have worked the sea as artisanal fishermen and sailors. While based on the islands of the archipelago, they have always maintained contact with the continent and with other islands in the Caribbean. The raizales generally navigate without having sight of land, with minimal instruments for this purpose. This is part of the ancestral knowledge of the raizal people. The raizales have always sailed and enjoyed the product of the sea without any restrictions from the political limits established by man. The sea is a vital space for the raizales, a trade route for Creole people in the southwestern Caribbean. It is their economic heritage. The sea is also their cultural heritage. In fact, followers of the Raizales faith are baptized in the sea. It is a cemetery for those who left and have not returned. It is the source of true and fictional stories, of tales, of fables, of adventures, of amusement and sadness. As the Raizales says, it's a gift of God. The habitat of the Raizales is formed by islets, keys, atolls, and banks. These range from San Andres and the islands in its proximity, which include south-southwest keys and east-southeast keys, to the islands of Serranilla and Bajo Nuevo, passing through Roncador, Serrana, and Quitasueño, and the islands of Old Providence and Ketlina. This habitat is an essential part of the Raizales' history, their livelihood, their culture. Madam President, distinguished judges, the sea provides the Raizal people and the people of the archipelago with food security. The banks and areas that are traditionally fished are reference points that are essential to the Raizales' livelihood and habitat. They include banks close to the Colombian islands. They also include, but are not limited to, banks farther out, such as Luna Verde, Cape Bank, Julio Bank, Northeast Bank, and Far Bank. These are much more than 12 miles from the coast, and since 2012, problems have arisen for the Raizales when they sail to fish in these areas. Eduardo Valencia Ospina will address these matters in detail. The Raizales are artisanal fishermen who use environmentally friendly techniques such as handlining and breath-hold diving. These are sustainable methods and practices geared to the special characteristics of the Western Caribbean maritime area. By contrast, other methods, such as fishing with divers who use scuba tanks, oxygen compressors, or explosives, cause serious harm. Unsustainable extraction of marine resources is a threat.
El líder raizal, Ken Francis James, está interviniendo ante la Corte Internacional de Justicia en la Haya. Es el primer colombiano en intervenir. Ya pues presentó el caso inicialmente el agente colombiano Manuel José Cepeda y uno de los puntos que expresó el exmagistrado Cepeda a la Corte es que Nicaragua estaría violando los derechos de la comunidad raizal que habita en el archipiélago de San Andrés, Providencia y Santa Catarina. Entonces lo que dice el líder raizal, Ken Francis James, es cómo la historia del pueblo raizal está anclada a este archipiélago mucho antes de esta controversia. Él habla de la llegada del pueblo raizal a este archipiélago cuando el reino británico empezó a meterse en el negocio de la esclavitud y pues todas las islas, como es conocido, de las Antillas y el Caribe, terminaron pues siendo grandes puertos esclavistas. Desde ese momento, las islas de San Andrés, Providencia y otros cayos como Quitasueño y Serrana se volvieron como el hábitat natural del pueblo raizal, el hábitat ancestral del pueblo raizal, donde pues su relación con el mar es a su vez histórica y, como dice Ken Francis James, por años, por siglos ya han podido extraer el producto del mar sin ninguna intervención. Y esto podría estar riñendo con la intervención de Nicaragua en la zona. Este va a ser uno de los puntos centrales de la defensa de Colombia, la intervención, la supuesta intervención de Nicaragua en los derechos ancestrales del pueblo raizal que habita el archipiélago de San Andrés, Providencia y Santa Catalina. Entonces, los dejamos finalmente con las palabras de Ken Francis James antes de que se retome la audiencia.
On their way of life and identity. Madam President, distinguished judges, I thank you for your attention, and I would be grateful if the floor could now be given to Sir Michael Wood. Thank you.
I thank Mr. James. I now invite Sir Michael Wood to take the floor.
Madam President, members of the court, it's an honor to appear before you on behalf of Colombia. On a personal level, may I say that it's a pleasure to be in The Hague and to be once again in the Peace Palace. May I first join in the tributes that have been paid to Judge Crawford. His passing is a great loss to the court and to all of us. My statement will be in two parts. First, I shall recall the basic elements of the specific legal regime at issue in this case. It is necessary to do so because Nicaragua presents the court with a false picture in its pleadings. Second, I will explain that Colombia's activities fall squarely within the freedoms and rights enjoyed by all states in the areas in question. Colombia has at all times had due regard to Nicaragua's rights and duties and has not violated any of Nicaragua's rights. Madam President, it's important to bear in mind the complex nature of the maritime area at issue in this case, the Southwestern Caribbean. As perhaps you can see on the screen, but anyway it's at tab 2 in your folders, the Southwestern Caribbean is a semi-enclosed sea bordered by 7 coastal states. To the south and west, Colombia, Panama, Costa Rica, and Nicaragua, with Jamaica, Haiti, and the Dominican Republic to the north. Colombia is not some distant maritime power. It is a coastal state in the Southwestern Caribbean, with an extensive mainland coast and numerous islands, including those of the San Andres archipelago. Colombia's activities and presence in the Southwestern Caribbean are a natural consequence of these geographical realities. In this context, Nicaragua's references on Monday to maps depicting the area of operation of the Colombian Navy, or to statements about having a presence in various maritime areas, are of no significance. States' navies regularly operate in areas beyond their maritime jurisdiction, even globally, to protect their interests. There is nothing unique or remarkable about Colombia having maritime interests and presence outside its jurisdictional waters. The peace and environmental sustainability of the Southwestern Caribbean are essential components of Colombia's well-being and form part of its national identity. Madam President, the applicable law in this case is closely related to this geographical situation. Account needs to be taken not only of the customary international.
Y retomamos la transmisión de la audiencia en vivo desde La Haya, desde el Palacio de la Paz de La Haya, sede de la Corte Internacional de Justicia, por el caso por presuntas violaciones de derechos soberanos de Nicaragua por parte de Colombia. Este caso se refiere a una demanda, a una tercera demanda que interpuso Nicaragua contra Colombia en 2013, luego de que fuera resuelto el largo pleito jurídico que planteó el país centroamericano contra Colombia por la jurisdicción que aseguraba tener sobre San Andrés, Providencia, Santa Catalina y toda la zona marítima que le rodea. Finalmente, la Corte en 2012, recordemos, dijo que Colombia conserva la soberanía sobre el archipiélago, pero ahora Nicaragua asegura que Colombia está violando sus derechos, pues derechos que tiene, por ejemplo, la pesca en estas zonas, y que Colombia incluso ha amenazado con el uso de la fuerza, algo que la Corte no va a entrar a estudiar. Y ahora, luego de que Nicaragua presentara sus argumentos iniciales el lunes, el 20 de septiembre, este 22 de septiembre, están interviniendo los abogados de Colombia. Inició el agente colombiano Manuel José Cepeda, luego fue el líder raizal Ken James, y ahorita estamos con el profesor estadounidense Michael Reisman, que interviene a través de Zoom, pues desde la Haya, y se está refiriendo en concreto a que la zona marítima, pues por la que están haciendo presencia embarcaciones colombianas, pues lo están haciendo en virtud de lo que se llama libertad de navegación, que es un principio del derecho internacional sobre el cual la Corte Internacional de Justicia no tiene mayor jurisprudencia, y le está pidiendo precisamente que se pronuncie sobre la libertad de navegación, en este caso en concreto.
Entirely different subjects, and there were thus no overlaps in substance between these two maritime zones, end quote. An EEZ state may not prevent and punish infringements of its own customs, fiscal, immigration, or sanitary laws and regulations in its territory or territorial sea, beyond its own contiguous zone. A fortiori, Nicaragua, in the name of asserted EEZ rights, may not prevent or punish violations of Colombia's customs, fiscal, immigration, or sanitary laws and regulations. Only Colombia may exercise such powers in a zone contiguous to its territorial sea. Madam President, in certain geographical circumstances, the contiguous zones of two states or a contiguous zone in an EEZ of another state overlap. If the coasts of the two states are less than 24 miles apart, each state will have only a territorial sea, and neither state may exercise contiguous zone powers in the territorial sea of its neighbor, for this would indeed infringe a coastal state's sovereignty. That is the only impermissible overlap, as the United States explained when it proclaimed its contiguous zone. Quote, the contiguous zone of the United States extends to 24 nautical miles from the baselines of the United States determined in accordance with international law, but in no case within the territorial sea of another nation, end quote. As much as Nicaragua would wish it, the Western Caribbean is not its territorial sea. When the coasts of two states lie 48 or more miles apart, and they apply equidistance to delimit their respective maritime entitlements, each state will have a 12-mile contiguous zone, which entirely overlaps with its own EEZ. The overlap is not duplicative or legally redundant, as its EEZ rights and contiguous zone rights are different. But if the two states' coasts are between 48 and 24 miles apart, let's say 40 miles apart, the two states' contiguous zones overlap, as you can see on the screen. If equidistance is applied to delimit their EEZs, the contiguous zone of each state will also overlap with the contiguous zone and the EEZ of the other. The nature of contiguous zone powers allows for such overlaps. As the Virginia commentary explains, quote, since the nature of control to be exercised in the contiguous zone does not create any sovereignty over the zone or its resources, it is possible for two states to exercise control over the same area if their zones should overlap for the purpose of prevention or punishment for infringement of the respective customs, fiscal, immigration, or sanitary laws and regulations within their respective territories or territorial sea, end quote. This is why the provision on the delimitation of contiguous zones was not removed because it was superfluous, as Nicaragua suggests. Nicaragua's proposition that an overlap is inconsistent with potential conflicts over the regulation of archaeological objects is misconceived, as is Nicaragua's own reliance on the Virginia commentary. The commentary did not suggest that the delimitation of contiguous zones was necessary. Rather, it recognized that contiguous zones may overlap and referred any theoretical disputes to the dispute settlement mechanism. Quote, Virginia commentary says, quote, since the convention did not adopt any provision regarding the delimitation of the contiguous zone, the possibility of disputes arising out of conflicting claims by states whose coasts are opposite or adjacent to each other cannot be ruled out, and Part 15, therefore, will be applicable, end quote. It's difficult to see why Nicaragua believes this passage supports its proposition that contiguous zones may not overlap, for it clearly supports the contrary position. But even if such theoretical conflicts occur, and the objects are not related to the cultural heritage of one of the states, UNCLOS Article 303 imposes a duty of cooperation between the states, which may simply resolve any disagreement. An overlap of contiguous zones may also occur when the territorial sea of an island of one state borders the EEZ of the other state. Then, the island's contiguous zone, ordinarily 12 miles in breadth, extends perforce into the other state's EEZ. Madam President, this is the situation before you. Because Colombia's archipelagic islands have a territorial sea, their contiguous zone adjacent to this territorial sea extends into the adjoining waters, regardless of whether Nicaragua claims resource rights in the overlapping area. Bear in mind that the term zone, whether used for the exclusive economic zone or the contiguous zone, does not designate comprehensive or residual rights to a body of water, but rather specific rights in a body of water which otherwise retains its character of high seas. For these powers, the term zone is descriptive of specific powers within a space rather than constitutive of a comprehensive spatial conveyance. Thus, it's wrong to say that a contiguous zone violates the EEZ of another state, because a contiguous zone right does not displace any of the rights of the EEZ state. The only possible claim could be that it has been applied in a particular instance without due regard to a specific EEZ right of the other state. Yet, even then, that would not undermine the overall legality of the contiguous zone powers. The fact that contiguous zone powers were not delimited by the court in 2012 does not mean, as Nicaragua would have it, that they were implicitly denied. Rather, the court's decision is consistent with the fact that a contiguous zone does not require a delimitation, as these powers are non-exclusive and don't conflict with any resource-related rights and jurisdictions of another state. The primary audience for indicating the contiguous zone is the Coast Guard or Navy of the state concerned. Madam President, for these reasons, Colombia submits that under customary international law, when circumstances so require, it may lawfully exercise contiguous zone powers within the space in which its contiguous zone.
El abogado Michael Reisman del equipo de defensa de Colombia le está pidiendo a la Corte que aclare un tema que seguramente será también muy debatido, y es la zona contigua que le corresponde a los territorios de San Andrés, Providencia y Santa Catalina, que recordemos pues la Corte ha reconocido la soberanía de Colombia sobre estas islas. Sin embargo, como ven en el mapa que está en pantalla, pues hay toda una controversia por cuál es la zona que le puede corresponder a estas islas para que Colombia, por ejemplo, pueda navegar y pueda ejercer sus derechos de pesca. La zona contigua es diferente al mar territorial, y la diferencia en esencia es la discusión que plantea el abogado Reisman, porque pues dice que las zonas contiguas de San Andrés, Providencia y Santa Catalina tienen territorios en común, y y juntas forman como una gran zona contigua que puede ser pues jurisdicción de Colombia. Pero Nicaragua piensa lo contrario y quiere quiere que la Corte reduzca esta zona contigua, que ha sido la interpretación de Colombia, para poder ejercer, por ejemplo, explotación económica, pesca en estas aguas que considera suyas. El abogado Reisman dice que como es un mar, como de todas estas islas, San Andrés, Providencia y Santa Catalina, tienen su propio mar territorial, pues en efecto sí se pueden juntar las zonas contiguas, como vemos en el mapa en rosado. En azul está el mar territorial, en rosado están las zonas contiguas, y como vemos empiezan, pues al juntarse unas con las otras, pues forman un gran mar, una gran zona marítima, pues que Colombia dice tener jurisdicción. Nicaragua, sin embargo, cree que Colombia debe limitarse a las zonas que estaban en azul.
On Nicaragua's rights. Should circumstances require it, it enables Colombia to effectively protect these legitimate interests in a fragile area, such as the San Andres archipelago. Colombia submits that the simplification of the contours of its contiguous zone promotes the public order and efficient management of a legitimate use of the oceans, and on the law and facts is justified. Colombia thus requests the court to reject Nicaragua's argument against the use of a simplified geodetic line for its contiguous zone. Madam President, Nicaragua distorts the powers claimed in Decree 1946 as amended by repeatedly quoting from a version it knows to be obsolete. I will proceed assuming that what Nicaragua meant to argue is that the powers in Decree 1946 as amended exceed what UNCLOS Article 33 allows. Nicaragua misses the point. It is customary international law that determines the rights of Colombia in its contiguous zone in accordance with current state practice and opinio juris. Colombia's study of state practice, found in Appendix B to the Counter Memorial, shows that states have claimed powers in their contiguous zones for security and defense matters, environmental concerns, and effects on cultural heritage. Even assuming, for the sake of argument, that the contiguous zone powers of a coastal state under customary international law are confined stricto sensu to those in Article 33, The question becomes the current meaning of the treaty's generic terms: customs, fiscal, immigration, and sanitary. You have instructed that when interpreting generic terms in long-term treaties, it should, as a general rule, be presumed that the parties, quote, have intended those terms to have an evolving meaning, end quote. That instruction applies to the generic terms in Article 33, which date back over 60 years to the ILC's 1956 draft articles on the law of the sea. Such terms should be interpreted in an evolutionary manner to enable a coastal state to protect its territorial sea and land domain from changing inbound threats without compromising the correlative rights of other states. Scholars have voiced support for an evolutionary interpretation of Article 33 to ensure their relevance to evolving threats. The prose commentary admonished that, quote, an all too narrow interpretation of the purposes enumerated in Article 33 should therefore not stand in the way of effectively combating new and serious threats, for example, those originating in vessel source pollution, end quote. The powers set out in Decree 1946 are 1, to safeguard the security of the islands, including from piracy and drug trafficking. 2, to protect against conduct contrary to security at sea. 3, to defend its national maritime interests, customs, fiscal, migration, and sanitary matters. 4, to preserve the island's marine environment. And 5, to guard the archipelago's cultural heritage. As Colombia's survey of state practice shows, for many of these powers, there is evidence of an emerging custom. Moreover, the contingent exercise of these powers, should the necessity arise, would deprive Nicaragua of nothing, as the powers are neither incompatible with nor displace any of Nicaragua's rights and jurisdictions. As Nicaragua lacks the powers to protect and preserve Colombia's islands, environment, security, or cultural heritage, and of course, no rights to act in a manner which violates Colombia's protective laws and regulations, the decree neither conflicts with nor displaces a corresponding Nicaraguan power. The powers in Decree 1946 are, it is submitted, consistent with customary international law on the contiguous zone and the EEZ. Decree 1946 provides that the application of these powers will be carried out in conformity with international law. On Monday, Nicaragua attempted to downplay Colombia's commitment in this regard. That may reflect the attitude of others, but not Colombia's, for whom this solemn commitment is not undertaken lightly. In 1956, the ILC deemed it unnecessary to include security because, quote, the enforcement of customs and sanitary regulations will be sufficient in most cases to safeguard the security of the state, end quote. Other security-related threats would concern circumstances that would be governed under self-defense. At the first UNCLOS conference, the motion to include security did not attain the necessary two-thirds support, but Colombia submits that under modern conditions, an evolving interpretation of Article 33 may now include Decree 1946's types of security concerns, specifically piracy and trafficking of drugs and psychotropic substances. These concerns would in any event come under the protection of the coastal states' customs, fiscal, and sanitary laws and regulations. Nicaragua seems to forget that these activities fall under the rights of third states through the operation of the principles set forth in UNCLOS Article 58, paragraph 2. Nicaragua's objection to the decree's inclusion of cultural heritage is ironic, as its own law and its contiguous zone claims such a power. As Colombia's survey of state practice demonstrated, multiple states have claimed powers to protect cultural heritage in their contiguous zone, reflecting the presumption in UNCLOS Article 303. Nicaragua objects to Colombia's power to protect the archipelago's marine environment from threats or acts emanating from the contiguous zone. Nicaragua has failed to show which of its enumerated environmental jurisdictions in Part 12 of the decree violates. Has failed to show which of its enumerated environmental jurisdictions in Part 12 the Colombian decree violates. For instance, UNCLOS Article 220, paragraph 6 empowers a state within its EEZ to address marine pollution to its coastline, but not to the coastline of another state. It is UNCLOS Article 221 which provides an example of the allocation of jurisdiction in one such scenario. Both provisions are in your folders at tab 35. Article 221 provides that, consistent with customary and conventional law, a state may, quote, take and enforce measures beyond the territorial sea, proportional to the actual or threatened damage, to protect their coastline or related interests, including fishing, from pollution or threat of pollution following upon a maritime casualty or acts relating to such a casualty. Article 221, paragraph 2 sets no spatial limit for this power, and the events activating this right.
El abogado Michael Reisman, representante de Colombia, se está refiriendo a dos puntos que pues ya había mencionado anteriormente el agente colombiano Manuel José Cepeda, y son, por un lado, que Colombia considera que puede ejercer, pues que puede defender la zona contigua con base en pues el asentamiento raizal que hay allí desde mucho antes de que Nicaragua expresara esta controversia. Es decir, los raizales que habitan el archipiélago de San Andrés y Providencia y que por siglos han ejercido allí sus actividades económicas, pues tienen unos derechos culturales adquiridos que Colombia le está pidiendo a la Corte que reconozca, y pues esos derechos, por ejemplo, son a la pesca en la zona contigua que Nicaragua reclama, pues que Colombia supuestamente le está vulnerando sus derechos sobre esa zona marítima. Es decir, pues el abogado Reisman dice que los raizales colombianos pues pueden ejercer la pesca en esta zona, y ahora se está refiriendo también a otra de las labores que Colombia asegura realizar en la zona contigua, que es pues la protección del medio ambiente, porque recordemos que en esta zona en disputa que rodea el archipiélago de San Andrés y Providencia está la reserva Sea Flower, la reserva de biosfera Sea Flower, una reserva natural pues que es hogar de miles de peces y especies marítimas. Y por último, anteriormente se refirió a la presencia de Colombia para combatir el crimen transnacional y la lucha contra el narcotráfico. Y en todas sus intervenciones ha citado pues, normas del derecho internacional que reconocen pues, que tanto para defender derechos culturales como para defender el medio ambiente como para combatir el crimen internacional, pues los estados pueden hacer presencia en sus zonas contiguas. Y anteriormente pues se había referido a la necesidad de Colombia de, como tanto San Andrés, Providencia como Santa Catalina tienen mares territoriales, pues sus zonas marítimas o zonas contiguas terminan superponiéndose una sobre la otra, creando una gran zona contigua que es sobre la que Colombia quiere ejercer jurisdicción. Y pues de nuevo, sobre esta gran zona contigua es que Colombia puede, por un lado, pues quiere, por un lado, proteger el medio ambiente en las reservas y Flower, dos, combatir el narcotráfico y tres, proteger los derechos culturales de la comunidad raizal que habita el lugar.
Evolutionary interpretation. By contrast, consider the breadth and scope of Nicaragua's law, number 420, which defines the extent of its contiguous zone powers. As you can see, in its contiguous zone, Nicaragua claims the unqualified right to prevent and punish violations of its criminal laws and regulations in its territory or territorial sea. Apparently, domestic criminal laws may extend at the state's will to include prohibitions far beyond the generic terms of UNCLOS Article 33. The sincerity of its objection to mere evolutionary interpretation of generic terms is cast into doubt by its own unlimited version of contiguous zone powers. Nicaragua complains that only 16 states claim security powers in their respective contiguous zone. Nicaragua is the only state claiming the unlimited power to control infringement of its criminal law. For these reasons, Nicaragua's objection to Decree 1946 specific powers should be rejected. Madam President, Nicaragua claims that Colombia's mere enactment of Decree 1946 constitutes an internationally wrongful act. But as the ILC explains, the applicable standard depends on the primary obligation, which in this case is one of conduct. Therefore, whether there is a breach will depend on where and how legislation is given effect, end quote. Nicaragua argues that the obligation which the decree violated is, quote, the preservation of the exclusive sovereign rights belonging to Nicaragua, is EZ, in accordance with Articles 56 and 58 of the UNCLOS, end quote. Its argument is misconceived. Should an occasion require Colombia to exercise its rights or perform its duties in any overlapping area, the applicable standard of conduct is to have, quote, due regard, end quote, to Nicaragua's rights in accordance with UNCLOS Articles 56 and 58.3. The due regard obligation, as the Arbitral Tribunal in Chagos Marine Protected Area recently explained, would not be an obligation to avoid any impairment of a state's right, a state's right within the EZ, but to balance the competing rights. And indeed, Decree 1946, which provides expressly that its application will be carried out in conformity with international law, represents such a commitment. Colombia's obligation with regard to Nicaragua's rights may only be violated, if at all, through the misapplication of the decree, not its enactment. The lawfulness of the decree cannot be evaluated based solely on whether its application in a specific incident has failed the due regard obligation. The powers enumerated in Decree 1946 are, as has been shown, consistent with international law. Moreover, Nicaragua has failed to prove that it suffered any injury by the enactment of Decree 1946 or by any purported failure by Colombia to accord, quote, due regard, end quote, to any of its rights. As to the question of whether the decree in itself is inconsistent with or impedes Nicaragua's claimed rights, the answer is simple. It does not. Madam President, all of Nicaragua's arguments against Decree 1946 have been shown to fail. Colombia's contiguous zone and its spatial extent are lawful under customary international law. So are the powers which may be exercised therein. Colombia cannot extinguish the legal effects of Nicaragua cannot extinguish the legal effects of Colombia's sovereignty over each one of the archipelagic islands, great or small.
El abogado Michael Reisman se refiere al decreto 1946, a través del cual el gobierno de Juan Manuel Santos definió cómo Colombia iba a ejercer soberanía sobre los territorios de San Andrés, Providencia y Santa Catalina, luego, y sus mares territoriales y sus zonas contiguas, luego de la decisión de la Corte Internacional de Justicia de la Haya. Con esta intervención, el abogado Michael Reisman termina su comparecencia ante la Corte. Acaban de decretar un receso y para la audiencia del espectador, la intervención de Reisman finalmente se centró en decir que el decreto 1946 de 2013, que según Nicaragua es una de las pruebas directas de que Colombia no ha cumplido con el fallo de la Corte de la Haya y que en cambio, pues a través de la expedición de este decreto, pues se está pues, desafiando la autoridad de la Corte. Lo que dice el abogado de Colombia, Michael Reisman, es que el decreto no viola derechos de Nicaragua y que solo violaría la soberanía de Nicaragua si de alguna manera se aplica mal este decreto, no con su mera expedición. Pues lo que dice el abogado es que el decreto define cómo él ha desarrollado, cuál es la interpretación de Colombia de su zona contigua, de sus mares territoriales, a partir de la decisión de 2012, dado que, como dijo el agente colombiano Manuel José Cepeda, pues Nicaragua no ha accedido a negociar con Colombia un nuevo tratado internacional, que es la forma a través de la cual... Listo. Que es la forma a través de la cual Colombia pues define sus límites con otros países. Con esta intervención del abogado Michael Reisman, Colombia pues va a atacar uno de los puntos fundamentales de la demanda de Nicaragua, que es la expedición de este decreto 1946 de 2013, que en su momento fue la forma, repito, del gobierno de interpretar la decisión de 2012 de la Corte de la Haya, y pues para Nicaragua es una violación de sus derechos, para Colombia es una interpretación de la decisión y por su mera expedición no significa una violación de derechos de Nicaragua. El abogado Michael Reisman además se refirió a... como la definición de las zonas contiguas en el derecho internacional y cómo la interpretación que le ha dado Colombia pues supuestamente estaría acorde con el derecho internacional. Asimismo, pues se refirió a pues una de las controversias que plantea Nicaragua, que es que las zonas marítimas, llamadas zonas contiguas, se están superponiendo. Las zonas contiguas de San Andrés, Providencia y Santa Catalina se superponen y crean una gran zona marítima, pues llamada zona contigua, sobre la cual Colombia puede ejercer jurisdicción. Para Nicaragua esto está violando sus derechos, pero el abogado Michael Reisman, a nombre de Colombia, dice que no, que Colombia está de hecho interpretando el derecho internacional y la decisión de la Corte de la Haya de 2012. Vamos a la pausa de 10 minutos mientras la Corte retoma la audiencia con una nueva intervención de otro abogado de Colombia.
Madam President, distinguished judges, may I be permitted to join the court and others who have paid tribute to the late Judge James Crawford, whose memory I had occasion to publicly exalt at the recent session of the International Law Commission. It is an honor for me to appear before you on behalf of my country, the Republic of Colombia. It is also a privilege to do so in the interest of the inhabitants of the San Andres archipelago, and in particular, the Raizales, who are listening very closely in their native Caribbean islands. This morning, Mr. Ken Francis James set the background against which to properly appreciate the importance of fishing for their survival. This afternoon, Colombia takes the floor to reassert their rights in the context of two counterclaims, one of which is of immediate relevance and paramount importance to the artisanal fishermen and communities of the San Andres archipelago, hereinafter referred to as the artisanal fishermen, who relied on fishing for their sustenance and livelihood. Colombia firmly believes that the two counterclaims, declared admissible in 2017, are well-founded in law and in fact. They are not, as Nicaragua dismissively puts it, an attempt to distract the court's attention from the real core issue. The counterclaims touch upon crucial questions such as the basic needs of the inhabitants of the San Andres archipelago, as well as Nicaragua's Strait Baselines Decree, which caused the unlawful extension of the Nicaraguan internal waters, territorial sea, and EEZ. Their assessment by the court, rather than impeding it, will greatly contribute to the sound administration of justice. Although Colombia raised the question of Nicaragua's infringement of the traditional fishing rights, what is the underlying main point of contention is the very existence of these traditional rights. Nicaragua does not simply ask to be clear of all responsibility for the bullying of the artisanal fishermen. It asks for more. Nicaragua wants this court to find that there are no traditional fishing rights whatsoever, or in other words, that the fishermen cannot fish where they have been doing so customarily, even before the coming into existence of Colombia and Nicaragua as independent states more than 200 years ago. Nicaragua's two-tier strategy is both unexpected and unfortunate. Unexpected because the highest representatives of both parties have explicitly recognized the existence of these traditional fishing rights. Unfortunate because we are dealing with an extremely delicate issue pertaining to social necessity, which Nicaragua is ready to accommodate, as it has remarkably written, although of course not today before this court. Nicaragua denies that the inhabitants of the San Andres archipelago have a vested right to conduct artisanal fishing. Yet, at the same time, it not only recognizes the fishing needs of the Raizales, but declares that it remains open in the spirit of brotherhood and good neighborly relations to reach a bilateral agreement on this matter. With due respect, Nicaragua's judicial strategy reveals the weakness of its argument. The traditional fishing regime obviously needs to be fleshed out. However, the conclusion of technical arrangements should not be confused with the existence and recognition of the existence of the traditional fishing rights. Nicaragua struggled to diminish the relevance and value of its president's statements. Likewise, Nicaragua struggled to distort and play down the affidavits of the artisanal fishermen annexed to Colombia's written pleadings. Nicaragua's repeated assertion that it remains open to find a solution that includes the fishing needs of the raizales, does not strengthen its case based on the alleged non-existence of the traditional fishing rights. It does the exact opposite. My presentation will be divided in two parts. The first is devoted to the existence and scope of the traditional fishing rights of the inhabitants of the San Andres archipelago. The second addresses the infringement of those rights by the Nicaraguan naval force. Colombia must embark anew in the examination of the affidavits annexed to its counter-memorial. Unfortunately, Nicaragua has deemed it appropriate to rely on selective quotations from those affidavits in order to put forward two unsustainable propositions, which convey the wrong picture about the geographic and temporal scopes of the traditional fishing rights at stake. However, before going into the affidavits, it is important to stress once more that Nicaragua's assertions are disproved by the words of its own president, who indeed has recognized the existence of the traditional fishing rights. Three statements he made after the delivery of the 2012 judgment must be considered in succession. On 26 November 2012, in the immediate aftermath of the judgment, President Ortega stated with reference to the fishermen of the San Andres archipelago, and I quote, "Nicaragua will authorize their fisheries in that area where they have historically practiced fisheries, both artisanal and industrial fisheries, in that maritime area, in that maritime space, where even before the ruling by the court, the permit was granted by Colombia, and now the permit is granted by Nicaragua," end of quote. This first statement constitutes an explicit recognition that the fishermen of the San Andres archipelago have historically fished in an artisanal manner in maritime areas located off the coast of Nicaragua. This brings us to the second statement the very next month. On 2 December 2012, when President Ortega met with Colombian President Santos during the inauguration of Mexican President Peña Nieto, the Nicaraguan president adopted a more concrete stance, recognizing not only the artisanal and historical fishing practice at stake, but also the traditional rights vested in the raizales. He stated, and I quote, "Be sure that we will respect the historical rights that they, the raizales, have had over those territories. We will find the mechanism to ensure the right of the raizal people to fish in San Andres so we can protect those people that live off the territorial sea," end of quote. Remarkably, President Ortega spoke of historical rights of the raizales. He stated that mechanisms will have to be established to ensure, that is, to make certain or guarantee that those rights already existing are effective instead of purely theoretical. His reference to the territorial sea is inaccurate. It again reflects Nicaragua's tendency to equate the EEZ with the territorial sea. What matters, however, is that Nicaragua's president had clearly in mind traditional rights to navigate and exploit banks in maritime areas located off the coast of Nicaragua. Let me stress again that if the first statement of November 2012 amounts to an explicit recognition of the long-standing artisanal fishing practices, the ensuing statement in December of that same year elevates those practices to the higher level of rights protected by law. The third relevant statement confirms this. On 21 February 2013, during the commemoration of the death anniversary of General Sandino, President Ortega was even more precise by declaring before the whole Nicaraguan nation, and I quote, "I told President Santos, and I have said publicly, that the raizales can continue fishing."
El abogado de Colombia en La Haya, Eduardo Valencia Ospina, que es el único colombiano que actúa como abogado de Colombia, es a su vez pues un reconocido autoridad en derecho internacional. Trabajó en la Corte Internacional de Justicia por cerca de 16 años y se está refiriendo a uno de los puntos centrales de la contrademanda de Colombia, que es que Nicaragua ha violado supuestamente derechos ancestrales de pesca que tiene la comunidad raizal colombiana en el mar territorial, en la zona contigua de San Andrés, provincia de Santa Catalina. Hace un rato escuchamos a Ken Francis James, un líder raizal que de su propia voz le contó a la Corte pues cómo los raizales han habitado esta zona por siglos, y ahora el abogado Valencia Ospina divide su presentación en dos partes. En la primera, que es la que está abordando todavía, se está refiriendo a la existencia de esos derechos ancestrales, a cómo incluso el presidente de Nicaragua, Daniel Ortega, en diferentes oportunidades ha citado hasta el momento dos muy importantes. En 2012 ha reconocido que esos derechos ancestrales de pesca existen. La segunda vez fue en diciembre de 2012 y lo dijo en una rueda de prensa pública al lado del presidente de entonces colombiano Juan Manuel Santos, en la posesión del presidente de México Enrique Peña Nieto, cuando el mundo estaba atendiendo a la publicación del fallo de la Corte Internacional de Justicia que le otorgó a Nicaragua 75.000 kilómetros cuadrados de zona marítima que antes era de Colombia. El presidente Daniel Ortega dijo que iban a hacer lo posible para que esos derechos históricos que ha tenido la comunidad raizal para pescar en esa zona pues se respetaran. En una segunda parte de su intervención, el abogado Valencia Ospina se referirá a cómo Nicaragua, contrariando las propias declaraciones de Ortega, sí ha violado los derechos de pesca de la comunidad raizal. Los dejamos entonces con la intervención del abogado Valencia Ospina.
More significant in terms of size and resources, are located at a similar, if not shorter, distance from San Andrés and Providencia than the distance between these two islands and Quitasueño, Serrana, and Roncador. According to the second, the artisanal fishermen do fish in Cape Bank and Luna Verde, but they started doing so only in the 70s, that is to say 50 years ago. There is apparently nothing traditional in what constitutes, according to Nicaragua's misguided perception, a contemporary phenomenon, the logical outcome of technological developments. Nicaragua's partial reading of the affidavit shows that there can be no effective substitute for the careful examination of the annexes at pages 373 to 427 of the counter-memorial. Obviously, those affidavits are replete with references to traditional fishing in the surroundings of what the artisanal fishermen sometimes call the northern islands, that is to say, Quitasueño, Serrana, and Roncador. It is therefore extremely convenient for Nicaragua to cherry-pick those excerpts from the affidavits which allow it to convey the erroneous impression that artisanal fishing mainly took place in Colombian maritime areas. Likewise, it can be easily understood why the artisanal fishermen's affidavits often focus on the time period they have directly witnessed, that is, up to the last 6 decades. But at the same time, those fishermen vividly recall that prior to the 60s, artisanal fishing by their forebears did take place in waters situated off the coast of Nicaragua. Before outboard and inboard engines became increasingly common in the San Andrés archipelago, artisanal fishermen relied on catboats, schooners, and sloops to reach Cape Bank, Luna Verde, and the other traditional banks. Such expeditions certainly require more preparation, time, and effort, but they nevertheless occur regularly during the appropriate seasons. This is not surprising, considering that the Raizales are a seafarer coastal community that has held close connections with its sister communities based in the Mosquito Coast, Panama, Costa Rica, Jamaica, and the Colombian main lines. In other words, Colombia does not deny that improvements in technology facilitate the fishing expeditions of the artisanal fishermen. Colombia, however, does refute Nicaragua's assertion that prior to these developments, traditional fishing did not take place in Cape Bank and Luna Verde in a manner sufficient to give rise to a customary practice. To further elucidate the thrust of my presentation, I must turn to the bathymetric figure number 4, included for illustration purposes in the judges' folders at tabs 41 to 43, which depicts the shallow banks in blue as well as the deep sea banks in purple. It provides an accurate visual representation of the banks mentioned by the artisanal fishermen. When I speak of shallow banks, I refer to areas where the seabed is located at less than 200 meters of depth. In this zone, there is enough life for photosynthesis to take place. It is in these nutrient-rich inshore waters that fishermen find the highest concentration of biodiversity, in particular the fish that thrive and form an essential resource of these sunlit waters. On the other hand, when I speak of deep sea banks, as the artisanal fishermen call them, I'm not referring to the open ocean offshore waters, but to banks located at seabed depths greater than those that characterize the shallow banks. They are nevertheless at depths usually well under the 500 meters isobath. They are adjacent to the shallower nutrient-rich waters and overall present more commonalities with inshore rather than offshore waters. There are, of course, small shallow banks in the maritime areas located on the Colombian side, but nothing compares even remotely to the shallow and deep sea banks located off the coast of Nicaragua. Turning to the Colombian maritime areas, there exist west of San Andrés, Providencia, and Santa Catalina, two contiguous throats, each of which reaches depths greater than 2,000 meters, resulting in only narrow shelf areas. The situation does not improve towards the east. On the contrary, east of San Andrés, Providencia, and Santa Catalina, we mainly find open ocean offshore waters, that is, depths much greater than 500 meters. The sole limited exceptions are the banks surrounding Roncador and the east-southeast keys, but the size of these banks, like the size of the banks surrounding San Andrés, Providencia, and Santa Catalina, again pales in comparison to the shallow and deep sea banks located near the archipelago and midway between Colombia and Nicaragua. Admittedly, there are larger shallow and deep sea banks located around Quitasueño and Serrana, two of the northern islands. Yet, they are not by themselves capable of meeting the food security needs of the inhabitants of the San Andrés archipelago, which brings me to address the other side of the equation, that is, the Nicaraguan side. Cape Bank is by far one of the most quoted banks in the affidavits. Cape Bank is in fact massive. It is an area around 30 nautical miles in width that extends for more than 100 nautical miles offshore from the entire Mosquito Coast. To the north, it reaches areas located well beyond 100 nautical miles from Cabo Gracias a Dios. East of Puerto Cabezas, Cape Bank extends beyond the 82nd west meridian in the area known as Luna Verde. Luna Verde extends significantly further east to that meridian, at a distance of approximately 100 nautical miles from Nicaragua's mainland. From Luna Verde, the eastern edge of Cape Bank then follows a south-southwest direction. This limit, the green line on the figure, is commonly referred to as La Esquina by the artisanal fishermen. This is where the shallow grounds of Cape Bank give place to its deep sea grounds. La Esquina constitutes one of the most important points of reference for the artisanal fishermen. West-northwest of Providencia, La Esquina largely follows the 82nd west meridian in the south, but curves eastwards towards the north in a north-northeast azimuth. This explains why that meridian is also mentioned by the artisanal fishermen in their affidavits. To the north, in the area known as Luna Verde, La Esquina is located significantly east of that meridian. To the south, on the other hand, La Esquina follows a northeast to southwest direction that brings it west of the 82nd west meridian. The artisanal fishermen have navigated and exploited every ground of Cape Bank. There are in the affidavits common references to fishing in the waters surrounding Bubble Key, Cabo Gracias a Dios, Rosalind Bank, as well as the Corn Islands. But when the artisanal fishermen speak of La Esquina, Luna Verde, or the 82nd West Meridian, when they broadly mention Cape Bank, they are generally referring to fishing grounds that are located around the eastern edge of Cape Bank. The artisanal fishermen thus fish in the shallow and deep sea banks located respectively to the west and to the east of the green line shown in the figure. Aside from the eastern edge of Cape Bank, the artisanal fishermen commonly refer to traditional banks north of Providencia, again in maritime areas located off the coast of Nicaragua. These banks included, but are not limited to, those discovered and named by the Raizales as Julio Bank, Northeast Bank, and Far Bank. They are located between the northern islands and in particular between Quitasueño and Providencia, as well as north of Quitasueño, not far from Luna Verde. The artisanal fishermen living in Providencia are those who most often refer to them. It is there, instead of closer to the shallow banks of the northern islands, that the artisanal fishermen find the fish of particular interest to the communities living in the San Andres archipelago. Instead of going now through each of the affidavits individually, I will focus on key findings that can be gathered by reading the sworn statements as a whole. Let me start by recalling that the Raizales who were interviewed in San Andres, Providencia, and Santa Catalina were artisanal fishermen long before they became adults. Their parents, grandparents, uncles, and aunts taught them the arts of their trade before they could reach adulthood, and the same is true with
Espina va a citar algunos extractos de entrevistas a personas de la comunidad raizal que habitan la zona de San Andrés, provincia de Santa Catalina, y que pues aseguran que la zona en la que han pescado ancestralmente coincide con las ambiciones de Nicaragua de ampliar pues su zona marítima. Este es uno de los puntos que Colombia discute y que pues seguramente será objeto de discusión profunda en la Corte, porque Colombia asegura que Nicaragua ha vulnerado derechos de la comunidad raizal al impedirles pescar en territorios que ancestralmente lo han hecho. Entonces, las intervenciones y los extractos de entrevistas pues que ha anunciado el abogado Valencia Ospina.
This is not true. In his very opening speech at the merits hearing of 2012, the agent of Colombia stressed, and I quote, "Since the 19th century, the population of the San Andres archipelago had been conducting fishing activities up to the Mosquito Coast, which have always been so essential for the archipelago's inhabitants that depriving them of these resources would entail serious consequences for their livelihood." End of quote. In any event, What matters is what Colombia has explicitly stated in the present case. While the practice of private individuals does not affect the course of maritime and land boundaries, maritime and land boundaries in turn do not affect traditional rights vested on the inhabitants of border regions. The jurisprudence in this regard, an excerpt of which you can see on the screen, decisively favors Colombia, an inconvenient reality that Nicaragua seeks to circumvent by relying exclusively on another argument, the alleged specificity of the EEZ, the one and only maritime area where, according to Nicaragua, traditional rights have been superseded. This issue has been amply dealt with in the written pleadings. What the court will also find in the affidavits is an explanation of what constitutes artisanal fishing as distinguished from subsistent and industrial fishing, as well as a description of its evolution in terms notably of means and methods. Artisanal fishing is a form of commercial fishing, which also entails, in addition to direct consumption, selling part of the catch. In this regard, artisanal fishing is different from subsistence fishing, which only aims to provide food on the fisherman's family table. However, despite this commercial connotation, artisanal fishing has much in common with subsistence fishing. As stated in most affidavits, artisanal fishing ensures food security in the San Andres archipelago. As the artisanal fishermen so often stress, artisanal fishing plays a crucial role for the subsistence of the inhabitants of San Andres, Providencia, and Santa Catalina. The line separating artisanal from subsistent fishing is overall a thin and blurry one. And what differentiates artisanal from industrial fishing are the methods involved and the two activities' production scales. One can usually tell whether a fisherman is engaged in artisanal fishing simply by looking at his boat and fishing gear. Artisanal fishermen use lines with up to approximately 10 hooks, harpoons, and sometimes traps. Artisanal fishing is not, however, an activity frozen in time. It has inevitably evolved and no doubt will continue to do so with technological developments. The affidavits give ample account of the evolution of the artisanal fishermen's boats, who first adapted the wooden sailing boats to leave space for outboard engines and later replaced many of these vessels with fiberglass lanchas. Some of the artisanal fishermen's boats nowadays have inboard engines as well as small refrigeration systems instead of boxes filled with ice and salt. The navigation equipment also evolved. Sextants and other instruments have been replaced by GPS and other electronics. Despite the evolution of the means and methods involved, artisanal fishermen have kept to their artisanal practices and remain faithful to the main aim of their activities, which is to sell products to their community living in the archipelago. There's clearly a social component to artisanal fishing, which is highlighted, among other things, by the policies adopted by the fishing cooperatives and associations based in the San Andres archipelago. Artisanal fishermen often share their boats and fishing gear with other artisanal fishermen. They likewise borrow the boats and gear of the cooperatives to which they are often...
El abogado Valencia Ospina dice que la forma de pesca artesanal que llevan a cabo las comunidades raizales que habitan el archipiélago de San Andrés y Providencia ha evolucionado con el tiempo. Esto para controvertir un argumento de Nicaragua que asegura que la pesca artesanal pues no existe en esta zona porque se ha tecnificado, cada vez más. Entonces, el abogado Valencia Ospina acude a la definición de pesca artesanal y a la forma en la que se hace hoy esta forma de pesca en San Andrés y Providencia. Y pues reconoce que es una pesca primordialmente con fines comerciales, pero para consumo interno de los habitantes del archipiélago, que de nuevo se ha hecho por años y que aunque algunos medios y métodos hayan evolucionado, la meta es la misma, que es proporcionar alimento para los habitantes del archipiélago. Este seguramente pues, es uno de los argumentos duros de Colombia y es, pues, como anunció el abogado Valencia Ospina, que los derechos de pesca ancestrales existen y que, por otro lado, Nicaragua los ha vulnerado insistentemente. Vamos entonces a seguir escuchando al abogado Valencia Ospina.
There is nothing exceptional for artisanal fishermen based in San Andrés, Providencia, and Santa Catalina to sail to Cape Bank, be it La Esquina or some of its internal banks located closer to the Mosquito Keys or the Corn Islands. In fact, the route to Cape Bank, which time and time again must have been used by the sister communities living both in the archipelago and in the Mosquito Coast, is shorter than the route to the northern islands. The artisanal fishermen have fished in all the waters surrounding these features, be it statically or while navigating from an island to another, trolling with one or a few lines. Likewise, they have fished in the waters of Luna Verde, which, when compared to the waters of Roncador and Serrana, are in fact located significantly closer to Providencia. Regarding the affidavits, Nicaragua asserts that all the accounts relating to the bullying of the artisanal fishermen by its naval force amount to hearsay. In its written pleadings, Nicaragua stressed that Colombia has adopted a tu quoque fallacy to justify its own claims, implying that Colombia's evidence appears to Nicaragua as equally inadequate as Colombia asserts that the evidence put forward by Nicaragua is. Yet, the truth of the matter is that under the conditions provided for by the court's jurisprudence, affidavits and second-hand accounts do constitute admissible evidence before the court. Those conditions are amply met in relation to the affidavits and accounts from the Raizales. The affidavits are consistent. Besides, the International Labor Organization's recommendations, which Nicaragua cites only when it deems it convenient to its cause, are also consistent. As the ILO has put it, quote, Raizal fishers have to cross Nicaraguan maritime territory, which is reported to give rise to difficulties and the payment of fines, close quote. Moreover, Nicaragua's own annexes, number 12 of its memorial, number 20 of its reply, are likewise consistent. They do refer to certain occurrences that have taken place. And it will be recalled that President Ortega himself had to instruct General Avilés not to detain or otherwise interfere with the artisanal fishing activities of the inhabitants of the San Andrés archipelago. Yet Nicaragua asserts that the most that Colombia's affidavits might be said to establish is that fishermen from San Andrés and Providencia have experienced some uncertainty in the wake of the 2012 judgment and that they are reluctant to fish in Nicaragua's waters. This is an egregious understatement. What the affidavits, the ILO recommendations, and Nicaragua's own annexes all indicate is that there have been occurrences between the artisanal fishermen and the Nicaraguan naval force. It is the latter that has instilled a climate of fear among the artisanal fishermen. This is confirmed in recent press articles that attest not only to the difficult situation of the artisanal fishermen, but also to the aforementioned occurrences, which include the arrest and detention of the fishermen by the Nicaraguan naval force. As portrayed in the affidavits, artisanal fishermen are approached and boarded by the Nicaraguan naval force. In the best case scenario, the Nicaraguan agents take food, cigarettes, and coffee from the fishermen, who of course cannot refuse. But in the worst case scenario, the Nicaraguan naval force take the GPS, VHF radios, the products, and all the fishing and navigation gear of value, leaving them adrift without the proper equipment. The artisanal fishermen have stopped going to many of the traditional banks due to these occurrences with the Nicaraguan naval force. The encounters take place on the way to Cape Bank when the artisanal fishermen are navigating along La Esquina or when the raizales are navigating and fishing between the northern islands. Quite apart from Nicaragua's irrelevant assessment of the jurisprudence relating to the drawing of maritime delimitations, such as the Gulf of Maine case, Colombia has demonstrated that traditional rights vested on indigenous people run with the land as well as with the sea. In other words, while the practice of private individuals does not affect the course of maritime and land boundaries, maritime and land boundaries in turn do not affect traditional rights vested on indigenous people. No doubt this court will hear from Nicaragua a plea on favors exclusivity, the idea that there can be no limitations whatsoever to its sovereign rights as a coastal state. The notion of exclusivity, however, is in no way specific to the EEZ. States enjoy full-fledged sovereignty, which is also exclusive, within their territory and territorial sea. Yet nobody, not even Nicaragua, suggests that traditional rights are incompatible with the exclusive rights that a state enjoys within its territory. As shown in the screen, the Eritrea-Yemen Tribunal rightly found that traditional fishing regimes are not limited by the maritime zones specified under UNCLOS. On the contrary, this tribunal, which was composed of no less than 3 former presidents of the International Court of Justice, rightly found that the traditional fishing regime operated beyond the territorial waters of the parties to the proceedings. In its written pleadings, Colombia has already addressed in depth this argument. I can therefore limit myself to point out that this whole debate as to whether traditional fishing rights have been superseded by the appearance of the EEZ becomes purely theoretical when it can be shown, as my pleading has done, that in any event both parties have recognized the existence.
Y el abogado Eduardo Valencia Ospina acude a citar jurisprudencia de un tribunal de Eritrea que pues, fue conformado por, entre otras personas, 3 expresidentes de la Corte Internacional de Justicia. Y este tribunal concluyó en un asunto similar que los derechos de pesca tradicionales no son limitados por los límites de los mares territoriales. ¿Eso qué quiere decir? Que, contrario a lo que ha dicho Nicaragua, pues los pescadores raizales colombianos que han ejercido de manera tradicional, histórica y ancestral la pesca en esta zona, que desde 2012 la Corte Internacional de Justicia le entregó a Nicaragua, podrían continuar haciéndolo bajo este argumento, pues porque han ejercido de nuevo este derecho de manera tradicional y hace parte de su cultura. Según el abogado Valencia Ospina, que con esto termina su intervención, pues una vulneración eventual de Nicaragua pues estaría en violación de ese principio. Vamos entonces con la siguiente intervención de un abogado colombiano. Los dejamos con sus palabras.
When Judge Crawford sat amongst you. And I'm here to present Colombia's arguments in support of its counterclaim regarding Nicaraguan Decree 33 2013 establishing the baselines related to its Caribbean coast. Now, that decree is provided at tab 46 of the judge's file. Those baselines are straight and at a considerable distance from the coast and have the mechanical effect of shifting the limits of Nicaragua's maritime spaces to the east and thereby encroach upon the rights of Colombia. Now, as we have seen since the beginning of these pleadings, what is at stake in this case is freedom to navigate, in particular the freedom of Colombian vessels to navigate. The very presence of those vessels is contested, or in the Caribbean Sea, is contested by Nicaragua. These straight Nicaraguan baselines are part of the same approach and are another blow to the liberty to navigate. They transform, under the innocent passage regime, vast swathes of exclusive economic zone into territorial seas, although those areas should be ones where the freedom to navigate prevails. Now, these baselines appear in orange on the card that you can see. Furthermore, those baselines transform territorial sea areas and even parts of the exclusive economic zone into interior or internal waters. And you can see that in bright red on the map. These lines project in an equally mechanical way. It projected the exclusive economic zone and Nicaragua's continental shelf in an equally mechanical way to the east, and this is what Colombia contests. Now, Your Honours, following the rather tense exchanges between the parties on the matter of admissibility of this counterclaim, the court found that it had jurisdiction to entertain it, given the nexus between Nicaragua's main claims concerning the Colombian decree establishing a contiguous zone and the Nicaraguan decree establishing the baselines. Now, in this respect, the court noted, and I cite, the parties are pursuing the same legal aim by their respective claims, since each is seeking a declaration that the other party's decree is in violation of international law. End of quotation. Now, the question put to the court in Colombia's counterclaim is therefore a limited one. The question is to know, and only to know, if Nicaraguan Decree 33 of 2013, by which that state established straight baselines in the Caribbean Sea, breaches international law. Colombia contends that that is the case, and that is what I am going to prove. In so doing, I won't be discussing that which Nicaragua would like to make the crux of the matter, and on which I imagine the court will needlessly be obliged to hear much. In other words, presentations regarding Colombia's domestic legislation establishing its own baselines. It is clear that the counterclaim is limited to one matter only, and that is establishing whether the Nicaraguan decree of August 2013 is or is not compliant with the requirements of international law. Now, I won't address any further the new claims made by Nicaragua regarding the base points which it says it intends to place on the alleged low tide elevations, which are said to be located, and where they are said to be located, as regards their baselines established in the impugned decree. That matter is irrelevant. It does not fall within the jurisdiction of the court, as it is totally unrelated to the decree. It is the challenge by Colombia to that decree has been deemed admissible by the court as a counterclaim. Incidentally, there is no support for the argument presented by Nicaragua in its additional pleading that that state could proclaim as a starting point for measuring the breadth of maritime zones with respect to that particular coast. Both
Estamos escuchando al abogado francés Jean-Marc Duvnon, que es representante de Colombia en la Corte de la Haya, y pues su intervención se centrará, según ha dicho, en la legalidad del decreto 33 de 2013 que expidió el gobierno de Daniel Ortega pues en el año 2013 y pues mediante este decreto, cree Colombia, Nicaragua intentó extender sus aguas internas y sus zonas marítimas más allá de lo que le permite el derecho internacional. Pues en esta controversia entre los dos países se discuten dos decretos para que vayamos precisando. Nicaragua cree que el decreto que expidió el gobierno de Juan Manuel Santos, el 1946, en el que pues reglamenta cómo va a ejercer soberanía sobre el archipiélago de San Andrés, Providencia y Santa Catalina, estaría violando el derecho internacional. Y por otro lado, Colombia cree que el decreto 33 de 2013 que expidió el gobierno de Daniel Ortega, pues estaría violando el derecho internacional porque, en pocas palabras, Nicaragua estaría corriendo la cerca de las aguas internacionales, de la zona marítima que le había otorgado la Corte Internacional de Justicia a aguas pues, que ya no le pertenecerían, a una zona marítima que ya no le pertenecería. En esa medida, el abogado Duvnon dice que pues, estamos frente a una controversia que se define pues, en qué tanto puede haber Nicaragua violado el derecho internacional con la expedición de esta norma. Los dejamos con la traducción del abogado Duvnon, que está interviniendo en francés, por eso la traducción simultánea de la Corte de la Haya.
1951. And this is reflected in Article 4 of the 1958 Geneva Convention on territorial seas and the contiguous zone, and indeed is reproduced practically word for word in Article 7 of the United Nations Convention on the Law of the Sea. Now, let me quote it to you. In localities where the coastline is deeply indented and cut into, that's the 1958 text, and in localities where the coastline is deeply indented and cut into, that's the 1982 text, or if there is a fringe of islands along the coast in its immediate vicinity, the method of straight baselines joining appropriate points may be employed in drawing the baseline from which the breadth of the territorial sea is measured. So, that is the text of 1958 and 1982, which in fact overlap entirely. The principle is therefore that it is possible to resort to straight baselines, and of course that is always more advantageous than normal baselines for the coastal state and always less advantageous for the other states. And this is recognized by customary international law, but only in truly exceptional cases. In Qatar, Bahrain, the court stated that the method of straight baselines, which is an exception to the normal rules for the determination of baselines, may only be applied if a number of conditions are met. This method must be applied restrictively. End of quotation. Now, I think that clarification must be borne firmly in mind. The method must be applied restrictively, and only if the necessary conditions are objectively met. However, even then, the straight baselines which the coastal state may then draw must meet certain requirements. The customary rule on this is codified by the text of paragraph 2 of the 1958 Convention, which is mirrored in paragraph 3 of Article 7 of the 1982 Convention. And I quote, "The drawing of straight baselines must not depart to any appreciable extent from the general direction of the coast, and the sea areas lying within the lines must be sufficiently closely linked to the land domain to be subject to the regime of internal waters." End of quotation. Madam President, members of the bench, Colombia maintains that the Nicaraguan decree does not comply with those rules. And other states share that view. Costa Rica has protested. The same applies to the United States, which has strongly contested what they call the excessive straight baselines of Nicaragua. You will find the text of those protests in the judge's file at tab 49. Now, as I will now demonstrate, these complaints are justified, as not only are the conditions not met for Nicaragua to be authorized to construct straight baselines, but what is more, even if the conditions had been met, quod non, the straight lines claimed by Nicaragua do not comply with the rules regarding their construction. Madam President, Your Honours, undoubtedly a simple glance at the configuration of Nicaragua's Caribbean coast will suffice for you to ascertain that the conditions clearly have not been met for Nicaragua to draw straight baselines along its coast. Nonetheless, at the risk of stating the obvious, please allow me to demonstrate just that. First of all, the two geographic situations in which a state may qualify to draw straight baselines is the first of the two situations is when the seafront has a particularly convoluted coastline. According to the customary exception codified in Articles 4 and 7 of the Conventions of 1958 and 82, the coast must present deep indentations and cut-ins. In other words, it has to be deeply indented and jagged. The type of coast concerned here is strikingly clear from the description of the Norwegian coast, which the court wrote in the Anglo-Norwegian fisheries case. And that coast, according to the court, is, and I quote, very broken along its whole length. It constantly opens out into indentations, often penetrating for great distances inland. The Porsanger Fjord, for example, penetrates 75 sea miles inland. End of quotation. The court adds that that coast is broken by large and deeply indented fjords. End of quotation. Now, the wording of the codifying texts, which we find both in the 1958 and the 1982 conventions, is not just a turn of phrase. No, it correctly reflects the customary law according to which, with the exception of the second scenario that I will return to in a moment, that only a coast which is deeply indented and with equally deep indentations cut into it affords the right to draw straight baselines. Indentations, concavities, rifts are not enough. The serrations of the coast must be deep. It suffices to view the line of the Caribbean coast of Nicaragua, which you can see now on the screen, to see that it in no way meets that requirement. It is neither convoluted nor deeply indented and cut into. And nobody, I think, will see deep indentations. Quite on the contrary, it is remarkably stable. Of course, we see that it slightly changes course to the south from Punta Perlas to Monkey Point and on as far as the Costa Rican border. However, that part of the coastline is nonetheless not deeply indented and cut into. No, the slight concavities are geographic forms which in no way, according to the rule, afford the right to employ a straight baseline unrelated to the coast as proclaimed by Nicaragua at that or in that area. So let me move on now to the second scenario. Now, Madam President, Your Honours, you will note that just as there is no deeply convoluted coast here in Nicaragua, there are no island fringes along it and in the immediate vicinity of it. The The term a fringe of islands along the coast in its immediate vicinity faithfully reproduces the jurisprudence of the court in the Anglo-Norwegian fisheries case. Then, according to the court, the test to be met to permit the drawing of straight baselines between islands situated facing a coast was that that coast had to be bordered by an archipelago such as the Skjærgård. In English, Skjærgård means rock rampart. Now, that image is particularly fitting as that formation is made up of approximately 120,000 island elements. Now, that suggests that in order to depart from the normal baselines, the coastal and island configuration must be exceptional in its nature. It must consist of a kind of island rampart, which is difficult to cross, and this between the coast and the open sea. The customary rule, which has since been codified, is phrased very slightly differently. It no longer refers to the concept of an archipelago, which perhaps might open the door to disputes, but the spirit is the same. The number, the form and arrangement of the islands in question must be such that the resulting island formation lends itself to comparison with a fringe, or to use a comparable image, is similar to a series of islands held in a relatively consistent line like beads on a string of beads. This fringe of islands, according to the customary exception, must be located along the coast in its immediate vicinity. Au contrario, the fringes of islands which are not along the coast and which lie, for instance, perpendicular to it or which extend seawards from it are irrelevant and cannot justify such an exception. Similarly irrelevant are island fringes which are not in the immediate vicinity of the coast. Moreover, the final islands in a fringe of islands extending perpendicular from the coast are progressively less and less in the immediate vicinity. This confirms that such islands do not meet the criterion required to draw straight baselines. Now, the Division for Ocean Affairs and the Law of the Sea of the United Nations organizations has very usefully applied this rule to practical cases and did so in its study of 1989 on baselines. Now, its work on this particular matter is very precise and remarkable. It concluded that there were two relevant types of islands that can trigger a departure from the rule regarding normal baselines. Now, the first case, and I quote the work done by that division, so the first case deals with islands which appear to form a unity with the mainland. Such islands appear to be dovetailed into the coast and on small-scale maps appear to be a continuation of the mainland. End of quotation. The second case, the second alternative, is, and I quote, when islands which are some distance from the coast form a screen which masks a large portion of the coast from the sea. However, the coast may be screened by a swarm of small islands, which by their number justify consideration as a fringe. End of quotation. Madam President, members of the Court, having set out these points, I will now turn to the case in hand. Nicaragua claims that the number of islands located off its coasts is very great in number, as it amounts to no less than 95. Now, these islands are said to lie between the coast and the main islands between which the straight baselines have been drawn. This group, according to Nicaragua, forms a fringe of islands along and in the immediate vicinity of its coast. However, that thesis is entirely without merit for three decisive reasons. First of all, Nicaragua does not furnish any evidence in support of its allegations. Rather, it simply provides a list of these alleged islands in Annex 31 to its reply. Now, the existence of these alleged islands must be proven. A list of names is quite clearly not a piece of evidence. What is more, when one simply reads this list, suspicions arise. For instance, Pigeon Key, White Rock, Guano Key, Frenchman's Key, and Sister Keys each figure twice on the list and are counted twice. Suspicions grow, to say the least, when one examines a little more closely the first islands claimed by Nicaragua. Or rather, sorry, the first, when one looks more closely to the first island claimed by Nicaragua when setting its base points, and I am referring to Edinburgh Key. This alleged island is of particular importance because, as we know, the impugned decree draws 8 straight baseline segments starting from a series of 9 base points. Now, Edinburgh Key is the second of them, and you can see it on the map, which is at the upper left of your screen, and which is an extract from Annex 2 of the impugned decree. However, the catch is that Edinburgh Key is not an island. According to the large-scale ocean maps used by Nicaragua, such as the NGA Nautical Chart 28130, Cabo Gracias a Dios to Puerto Isabel, filed as Appendix 5 to their additional pleadings. Now, indeed, as you will see, if you look at the extract which was presented at the bottom left of your screen, which can only be understood in light of the legend of the map which we have produced on the right-hand side of the screen, Edinburgh Key cannot legally qualify as an island. Nonetheless, Nicaragua purports that it can place a base point there. Nicaragua has therefore in no way proven the marine geography on which it bases its actions. Secondly, it is manifestly inaccurate that the 95 alleged islands form a fringe of islands along and in the immediate vicinity of the coast, from the Honduran border to Monkey Point. Indeed, even if one accepts that the 95 alleged islands exist for the sake of argument, they are located in 3 different geographic zones, which are independent and at a distance one from the other. The islands and islets within those zones would, furthermore, be largely oriented perpendicular to the coast and extending in a seaward direction. Incidentally, you simply need to look at the map to see that those islands do not produce any masking effect. Even if their existence were to be proven, they do not form a fringe of islands situated along and in the immediate vicinity of the Nicaraguan coast in the Caribbean Sea. In other words, although the criteria for drawing straight baselines requires that the coast be screened by a swarm of small islands which by their number justify consideration as a fringe, Nicaragua only presents a few islands, rocks and low tide elevations concentrated in 3 distinct geographic zones, each remote one from the other. Nicaragua defends its theses by relying on the Norwegian practice, which it claims shows that linking groups of islands which are separated by tens of nautical miles is not incompatible with the existence of a fringe of islands along the coast. However, aside from the fact that the Norwegian practice to which Nicaragua refers does not constitute a rule of law, it is clear that the Norwegian coast is radically different to the one that we are studying today. One simply needs to look to see that it perfectly illustrates the first scenario in which a fringe of violence may authorize use of straight baselines. That is to say,
El abogado Jean-Marc Tournon de Colombia está mostrando en este momento un mapa de Noruega porque el decreto que Colombia critica y reprocha de Nicaragua, que es el decreto 33 de 2013, se basa en una interpretación noruega de cómo se puede construir pues, su zona marítima. Recordemos que este decreto 33 de 2013 lo que hizo Nicaragua fue trazar líneas rectas desde sus costas para así dibujar los nuevos límites a partir de la zona económica exclusiva que le concedió la Corte de la Haya en 2012. Entonces, para Colombia, con esta decisión, lo que hizo Nicaragua fue correr la cerca, literalmente, y ampliar sus mares territoriales. Aquí vemos una comparación entre el mapa de Noruega y el mapa de Nicaragua. Entonces, lo que está diciendo el abogado francés Jean-Marc Tournon es que Nicaragua pues no puede hacer uso de esta interpretación noruega porque pues no tiene las islas suficientes para expandir tanto su línea de costa y en cambio pues presentó como argumento para hacerlo lo que realmente serían rocas, elevaciones de tierra, pero no islas en sí, como supuestamente dice él, lo exige el derecho internacional.
Such that they would justify the drawing of straight baselines at those locations. Indeed, their general orientation is not parallel to the coast, but perpendicular. They are positioned not like a fringe parallel to the coast, but rather they look something like what one would, to draw an image, look like what one would see if a child were to throw a fistful of stones out to sea from the coast. And that's why their screening effect is practically insignificant. The screening or masking effect of 10 hypothetical small islands perpendicular to the coast does not have a cumulative effect, but rather has the effect that would be the equivalent of a large island, or even a small number of islands. That is indeed one of the factors, and only one of the factors because there are many more, which distinguishes the configuration in question or under discussion here with that which was examined in the Eritrea-Yemen case. In that case, the islands discussed by the arbitration tribunal, notably Tikfash, Kutama, and Ukban, extended from the Ras Isa Peninsula on a projection almost parallel to the coast. The tribunal spontaneously observed, and I quote, an intricate system of islands, islets, and reefs which guards this part of the coast. End of quotation. In other words, a formation which corresponds not only to one, but to both of the scenarios set out by the United Nations Division for Ocean Affairs and the Law of the Sea, which I referred to a few moments ago. And rightly so. Not only are the Yemeni islands not only do the Yemeni islands dovetail into the coast, as together with the large island of Cameron, they lie as an exact continuation of the Ras Isa Peninsula along the coast and give the impression of being an extension of the peninsula. Not only that, but they also yield a very considerable screening effect given their large number and the way they run along the coast and do not run seawards out into the sea. The Nicaraguan coast and its islands do not resemble that in any way. It should be added that the seaward layout of the islands, in this case, preclude Nicaragua from claiming that its furthermost islands, which are up to 24 nautical miles from the coast, are immediately in the immediate vicinity of the coast. The court will note that the parties have already presented their views regarding the matter of whether 20 nautical miles from the coast is a distance which is compatible or not with the concept of immediate vicinity. Colombia accepts that the rule of immediate vicinity is not mathematical. It does, however, have a certain logic. It encompasses the requirements that a fringe of islands running along the coast forms a certain unity with that coast, even if it does not dovetail with it, but rather is detached from it. Now, the further an island is removed from the coast, the less it is possible to claim that it forms a unity with that coast. In the case in hand, there is no geographic unity between the coast and the Nicaraguan islands through which the contested baselines pass. Madam President, Your Honours, suppose that the geographic conditions were met for straight baselines to be drawn, contrary to what I have just demonstrated. On the one hand, the straight baselines drawn it would be important that they do not deviate substantially from the general direction of the coast. And on the other hand, the expanses of sea located within them must be sufficiently linked to the land domain to be subject to the regime of internal waters. Now, Nicaragua's system of baselines fails in these two respects. The requirement that these straight baselines follow the general direction of the coast is in line with the principle that to be allowed to draw such lines, or being allowed to draw such lines, must be the exception and must solely be for the purpose of simplifying the drawing of the baselines. It does not authorize a coastal state to draw any line, a line which is too far removed from the normal baseline, which for its part must follow the meanders of the coast. In the case in hand, the lines which have been drawn by Nicaragua cannot be considered as following the direction of the coast. Rather, that direction is simply ignored at three locations. First of all, between Cape Gracias a Dios and Edinburgh Key. Edinburgh Key, that's the one I indicated to you a few moments ago on the map of Nicaragua. I see the map on the screen, so let me repeat. Between Cape Gracias a Dios and Edinburgh Key, and as I said, Edinburgh Key is what I told you a few moments ago is not an island based on the maps used by Nicaragua. The alleged Nicaraguan baseline, which runs east-southeast for approximately 30 nautical miles, makes almost a right angle with the line of the coast, which runs southwest. Not only is that line totally unrelated to the direction of the coast, but it alone single-handedly shows that the system of baselines produced by Nicaragua is artificial and does not comply with the requirements of international law. A second problem area is between Man of War Key and Little Corn Island. There, the line takes a southeastern direction, although the coast runs south. This leads to the alleged Nicaraguan baseline running a further 17 nautical miles from the coast, given that Man of War Key is approximately 12 nautical miles from the coast, whereas Little Corn Island is located 30 nautical miles from the coast. And then finally, thirdly, between Great Corn Island and the endpoint of the Nicaraguan system of straight baselines, so between Great Corn Island and the endpoint of this Nicaraguan system of straight baselines, which is at point 9 in the far south, the line has strictly nothing in common with the coastline. In fact, Nicaragua seemed to have claimed that in its dispute with Costa Rica. To the left, you see the general direction of the southern part of the coast, as shown by Nicaragua in page 95 of its counter memorial of the 8th of December 2015 in the case regarding maritime delimitation with Costa Rica. And to the right, you see the baseline, which in principle should faithfully run along the general direction of the coast, but in fact does not do so at all. In fact, the deviation is striking. I now turn to the final test, and that is the link to the land domain, which is necessary in order for waters to be subject to the regime of internal waters. Now, the court will note that the surface of the sea, which is claimed by Nicaragua off its continental coasts as being part of its internal waters, in other words, subject to its sovereignty in the same way as its land territory, that it amounts to approximately 21,500 square kilometers. Now, that's the equivalent of twice the territory of Jamaica, or the entirety of the land territory of El Salvador or Belize, or 2/3 of the surface area of Belgium, or half of the surface of the country in which we are today. In such an extreme case, elements attesting that the claimed waters are sufficiently linked to the land domain to be subject to the regime of internal waters need to be obvious. But in fact, in this case, they are inexistent. At a purely geographical level, there is no particular link between the waters claimed to be internal and the configuration of the coast and the claimed coastal islands. The surface area of the islands in those waters is negligible with respect to the very large surface of the said waters. These alleged islands do not enclose in any way the waters such that they render them subject to the regime of internal waters, and thereby renders them subject to that regime. Those islands do not form jewels, which together with the coast capture those waters, and the screening effect of the alleged Nicaraguan islands is extremely weak, and it only goes to confirm that the waters are far more linked to the sea than to the land. The straight baselines artificially drawn between Mysticos Key and Man of War Key and between Corn Islands and Point 9 cannot justify alone there being a link between those waters and the waters which surround them, between those waters and the surrounding waters and the coast. Incidentally, Nicaragua has not presented any serious argument justifying any kind of a link between those claimed waters, which would indicate that they are internal waters which are linked to its territory. Simply, it claims that 81% of those waters would be part of what would be its territorial sea if the normal baselines were drawn along the coast. Well, be that as it may, that in no way justifies those waters being claimed as internal waters. Nicaragua alleges that those waters are also exploited by Nicaraguans who use them as fishing grounds and for other activities. They also refer to a protected biological zone which has been established to the north of the zone. But that does not in any way explain why those practices or how those practices justify full, complete and exclusive sovereignty of Nicaragua over these vast expanses of sea which extend between the normal baselines and the straight baselines, and which thereby encompassing waters which they claim to be internal. also by looking at this card, which represents the biological reserve zone, which covers the Mosquitos Keys on the one hand and the adjacent coastal strip. We will see that there is in fact no connection between those two areas. The sites which are covered by the Ramsar Convention on Wetlands, according to the website of that convention, show that there is no link between the two sites. It is only around the Mosquitos Key that a Ramsar site has been identified, and that site does not reach as far as the coast. Madam President, I now come to my conclusion, which is very simply that there is no justification affording Nicaragua the right to use a system of straight baselines to establish its baseline in the Caribbean Sea, and in any case that the lines that it has drawn are entirely without merit in international law, and that the impugned decree is therefore in breach of international law. Thank you very much for having allowed me those few extra moments. Thank you.
I thank Professor Tuvenan, whose statement brings to an end this afternoon's sitting. Oral argument in the case will resume on Friday, 24 September at 3 p.m., when Nicaragua will present its observations on the counterclaims of Colombia. The sitting is adjourned.